This is an appeal in the matter of Gutmann and Apple and others.
May it please the Court, in this appeal from a decision of the Competition Appeals Tribunal, I appear with my friend Lucinda Cunningham for Apple, and my friend Mr. Bacon, King's Counsel, appears for Mr. Gutmann, the class representative.
Reduce from the skeleton argument, so you come with fewer people on this occasion.
My Lord, yes. We have a focused team.
just before you start, have we got a transcript? Or
We have a transcript being done remotely, my Lords.
is that so we don't need to worry too much about writing down every single one of your appeals as we go along?
My Lord, yes. The transcript will be provided to the Court in the usual way. It's being done, as I understand it, in the normal way, save that the transcriber is not physically in this room, but he or she is on a remote link.
Good. Okay.
Now, as my Lords will have seen from the written arguments, we have two grounds of appeal. I thought I would just take a moment, if I may, to sketch out how we submit the relationship works between the two grounds of appeal. And then I'll go on, obviously, to develop the first ground, which is the jurisdictional ground, and then I'll come to ground two. So the first ground is the jurisdiction question. Essentially, whether it is legally permissible for the funder to be paid in priority to the class out of proceeds, whether that is legally permissible under the Act and the tribunal rules. And that is, in my respectful submission, a question which admits of a yes-no answer. The second ground is whether it was just and reasonable for Mr. Gutmann to be authorised as the class representative, where he's entered into an agreement whereby he agrees to seek and advocate for payment of the funder's fee in full out of damages due to be distributed to the class and before any such distribution has taken place. And just for the Court's benefit, when I say something like funder's fee or funder's return, we know what we're talking about. We're talking about essentially the success fee, and I'll show the Court the documents. Now, to explain the relationship between the two grounds, if we succeed before my Lords on the first ground, the appeal must be allowed and the tribunal certification decision should be quashed. That's because Mr. Gutmann would have entered into an LFA, which is contrary to statute and would be unenforceable. And that necessarily makes it impossible for him to satisfy the authorisation condition on the claim as presently formulated. However, whether or not we succeed on our first ground, we have an additional point on our second ground. Now, if we have one on our first ground, we say on our second ground that Mr. Gutmann shouldn't be authorised even if he goes away and obtains new funding arrangements which are permissible under the statute. And we would say that because by entering into arrangements which deprive the class of what is rightfully theirs, which is the hypothesis underlying the jurisdictional point, he would have shown himself to be unsuitable to defend the interests of the class. But even if we're wrong about the first ground, such that it's technically jurisdictionally open to the tribunal to order that damages that the class members want to collect can be used to pay the funder first, then on our second ground it still leaves open the question of whether it was appropriate for Mr. Gutmann to undertake a positive obligation, a contractual commitment, to argue for that outcome. And we say it was not, and so the tribunal erred in finding that Mr. Gutmann could fairly act in the interests of the class as the class representative in these circumstances. Now, the consequence of our appeal...
It's a difficult point, though, in the sense that even though you can say they gave permission to appeal, but on the second ground, I mean, that involves the tribunal in an evaluative judgment, which is essentially for the tribunal. And follow your first ground. If you're right on your first ground, well then it's effectively out of court. On your second ground, I think it's much more problematic in this court.
Yes. Well, my main submission would be this court should essentially grasp the nettle And we can see how the tribunal approached it, and in these circumstances, we would submit for the consequences which I've just set out. The alternative would be, I mean, plainly the tribunal hasn't considered the point which my lord has just put to me, because they proceeded on the basis that there was jurisdiction. The alternative might be to remit that point back to the tribunal.
Yeah.
Now, but we do say, though, our primary position is that the consequence of the appeal succeeding on either ground is that Mr. Gutmann did not and never did meet the authorisation condition. And since the Act, that's at 47B5, requires both the authorisation and eligibility conditions to be met in order to certify, the claim should never have been certified, and so the tribunal should have declined to issue a collective proceedings order because he failed to meet the authorisation condition. And of course, the CPO was issued in this case. So we seek an order that the tribunal's decision to certify be quashed or overturned. And of course, had the tribunal properly declined certification, the CPO application would have been dismissed, there would have been no CPO, and that will be the end of the road for Mr. Gutmann's CPO application.
Yep.
Now, I was now proposing to set out 5 points of common ground, because in my submission it will help clear away some points, and then we can focus on what really is an issue today. First, it's common ground that the revised LFA is now premised on the basis that the Act permits payment of the funder's return in full from the damages award prior to distribution. And I say now because before the Supreme Court handed down its judgment in Packard, the original LFA contained no obligation on Mr. Gutmann to seek to advocate that the funder be paid in full from damages prior to distribution. And I'll give my lords the reference. It's in the supplemental bundle at tab 6. Tables 1 and 2 of that LFA did contemplate in priorities waterfalls 1 and 2 that the funder's return could come from either stakeholder proceeds and under table 2 and the priorities waterfall 2, and then other than stakeholder proceeds under table 1 and priorities waterfall 1. So to that extent, it mirrored what we've got now. But the difference is that in the original LFA, there was no obligation on Mr. Gutmann to argue before the CAT that the funder be paid in full from proceeds prior to the amendments which followed Packard. And importantly, and I'll come back to this point, Mr. Gutmann has never provided any explanation for that change. He's never explained why it is and why it's in the interests of the class for him to take on that contractual obligation. In the original LFA, the extent of his obligation to the funder was to use, and I quote, best endeavours, quote, to ensure that amounts due to the funder were paid from undistributed damages, i.e. That's what we say is the only permissible route under the Act. That's the first point of, well, it must be common ground. Second, and this is in my submission very important, it's common ground that Mr. Gutmann's claim would continue to be funded by the funder where it can only be paid its funder's return from undistributed damages. And this is expressly contemplated in the alternative. Timberland defends skeleton at paragraph 22, and we can also see that from the LFA schedule, which is in supplemental bundle tab 6, schedule 2 above table 2 on page 32.
Supplementary bundle tab 6.
Page 32, my lords.
Yeah.
And essentially, table 1 is where it comes directly from the damages award, i.e. the point where we're arguing is the jurisdiction to do it. In other words, is a jurisdiction to do Table 1. But in the alternative, it'll come under Table 2. So this isn't a case where if I'm right on jurisdiction, the position is there's no funding. On the contrary, the funder has contemplated funding on alternative bases. And I'll come back to this point, but my lords will have picked up the delta, if I can call it that, between the multiples in Table 1 and Table 2 is not great. So we can see that commercially, the funder is not saying here, oh gosh, I'm going to be taking a huge risk if Apple is right on the jurisdiction point and I only get paid from undistributed damages. On the contrary, it's a small increased risk we see so far as the funder itself contemplates matters of only being paid after distribution. That's the second point. Third, it's also common ground that initially Mr. Gutmann himself only contemplated that the funder would take its return from undistributed damages. And this was made clear in Mr. Gutmann's witness statement in support of the claims at the certification stage. Now, this isn't in the bundle. I'm happy to hand it up if needed, but it's really only one paragraph, which I'm going to read out, and it'll be on the transcript. This is in the first witness statement of Mr. Gutmann at paragraph 64. I'll read it in full, it's not long. Specifically, in return for balance, that's where the capital B, they're the funder, funding the proposed collective proceedings, and because any adverse costs awarded in my favour is unlikely to cover balance's funding outlay, if the proposed collective proceedings are successful and there are any unclaimed damages at the conclusion of the proposed collective proceedings, I intend to make an application to the CAT under section 47C6 of the Act for the CAT to allow a payment to be made to balance from any unclaimed damages. And that's clear. And it's also worth noting that, as I mentioned earlier, there's no evidence of Mr. Gutmann explaining why he saw fit to accept the amendment to the LFA clause 10.4, which goes into Schedule 1, obliging him to prioritise the interests of the funder over the interests of the class by seeking an order that the funder be paid in priority to the damages owed to the class. He doesn't say, for example, I went round the market, I couldn't obtain funding on any other basis, or any other funding would have been prohibitively expensive, or the market will only fund cases on the basis of funders being paid prior to the class receiving their damages. There's no such evidence. Fourth, it's common ground that the commercial return to the funder, the funder's field, the funder's return, constitutes, in the language of the Act, an expense within 47C6, or in the language of the rules, a fee or disbursement within Rule 93.4. And that is what the tribunal can order to be paid to a class representative from undistributed damages. I'm going to take the court, obviously, to the Act and the rules in some detail in a moment. Fifth and finally, it's common ground, as noted by the tribunal, that all the authorities in which the discussion has taken place so far are obiter. And I appreciate that one of those decisions is this court's decision in terms of jurisdiction, and also 2/3 in terms of members of the Constitution in Le Paturel and BT.
It's a long time ago, we can't remember it.
We also have an open mind.
Oh yes, that as well.
Well, look, I was certainly relying on the second point. The first point is helpful, but I will show the court is, and I mean, of course, it will go without saying that insofar as I will be critiquing the court's decision, I do so with respect. But the court will recall that in that case, it wasn't just obiter, as it appears from the judgment. The point was argued very briefly, if at all.
Yeah.
The point we're actually on.
But if it helps you at all, and from recollection, I don't think these issues have ever really crossed the court's boundary.
That was what we were thinking about in the previous case was account credits.
Exactly.
in respect of people's phone accounts, which
It-
is a different creature altogether.
And it was really the point at which damages ends and distribution starts.
Precisely, yes. I mean, I'll come, if I may, to that case when we look at the cases. And of course, it'll be important probably for both of us, for the court to consider what it said in that case. But in my respectful submission, the answer isn't going to be there, not least because that
But it's in
wasn't...
the statute of the rules,
Well,
ultimately.
I'm going to be starting with the statute and rules, and I will be submitting that, so to speak, I could finish my submissions with the statute and the rules. I'll need to show the court the cases because Malone and Friend relies on them. But my case is really pretty simple. It's read the statute, read the rules, and the rules can't go beyond the statute. I mean, these are basic propositions which ought to be uncontroversial. And we say, when we get to the cases, as my Lord Justice Green has just put to me, that the statute provides really a complete code together with the rules. And whether we're dealing with direct credits, that's a different question. Whether we're dealing with collective settlements, that's also a different question. Different rules, different reasoning, different function for the tribunal. And even in that context, we would say that the tribunal should not permit the funder, can't permit the funder to dip into the pot allocated to the class. Now, what we say, therefore, turning, if I may, to the statute, because that has to be the starting point, is our first point is, on a plain and ordinary reading of 47C, which I'll come to, the tribunal simply does not have jurisdiction to order that the funder's return be paid out of a damages award in priority to the class. And as I've said, we could really stop there. If we need to adopt a purposive construction to the statute, although we say we don't because the words are clear and make sense, we do submit that our interpretation accords with Parliament's intention with respect to damages awards in collective proceedings, and we end up with the same result. And we say that because, as we will see, the underlying policy behind 47C was to provide compensation and redress for loss suffered by the class. And there is a balance to be struck between ensuring that the proceedings are conducted in the best interests of the class, which should prevail over the interests of the funder, but at the same time recognising that the funder is entitled to a return after class members have been given the opportunity to claim damages. And that means, necessarily and intentionally, that funders always bear the risk that there is no or no sufficient part of the award of damages left to pay their return either in whole or in full. And we say that is clear from the statutory scheme and also from the judgment of Lord Sales in Packard, which we'll come to at paragraph 98. Now, that means that there is a commercial risk inherent in the funding business. Of course, there's a risk that the claim may not succeed at all, and the funder won't be paid in those circumstances either. And the risk as to when the funder has been paid has been quantified in this case helpfully by the funder as to Table 1 and Table 2. And as I said, the delta is not substantial. But even if the delta were substantial, my central submission is that Parliament has decided that the risk of not being paid is not to be borne by the class members.
Why would any funder enter into litigation of this sort on such a basis? Obviously, one accepts the risk that you fail. I mean, another way of looking at Parliament's intent was to provide, it was quite explicitly, a market-driven form of litigation. And that's why we have on a number of occasions and said, well, there is a balance to be struck. Cat, you've got to exercise that control. But we've always recognised the funders, the system wouldn't work without the funder getting a proportionate reward.
Yes, the funders are not registered with the Charities Commission. I absolutely accept that. And the reason is that when the system was set up and the supposition underlying the whole system, but importantly underlies the way the Act has been formulated, is that the take-up will be relatively low. And because the take-up is relatively low, even if the funder gets paid at the back end, if I can call it that, we know what we're talking about, there will be enough for the funder to get paid. And indeed, this case is a very good example of that. If my lord looks again at table 1 and table 2, the funder is saying, I'm content to take the commercial risk that I'm only paid at the back end. I will want a little more return for it, but not a lot. But I'll fund the claim on that basis. I mean, there is zero evidence before the courts that if I'm wrong on the jurisdiction point, funding will dry up. The evidence we have is that if I'm wrong on the jurisdiction point, this funder will fund on table 2, and there will be funding for this claim. And I'll come to that, if I may, a little bit later, because I want to show the court the way in which that balance has been struck, and the theory underlying it. And we can also dip in, which I hope the court will find interesting, to a couple of academic articles on the topic.
Yeah.
Now, our primary position is that the effect of sections 47C 3 to 6 taken together is that expenses or fees and disbursements incurred by the class representative, such as a funder's return, can only be paid from undistributed damages. So let's start with what the statute actually says. This is in Authorities 22. I don't know if the court is working electronically for the authorities or off paper. If it's electronically, it's 22. If it's off paper and the court has my divisions, it would be in file 4.
Yeah.
And we can turn to 903, and I appreciate the court has looked at this several occasions before.
Yeah.
Subsection 2. So the starting point is, tribunal may make an award of damages without undertaking an assessment on an individual basis per class member. Now, of course, we know this, but let me just mention a point which I'll come back to, because it's a point learned friend relies on. He has a point about what he calls full compensation. Now, with respect, that is a red herring. Under this regime, where a damages award is issued, the idea is that the class receives collective redress for the wrong, and class members who claim their entitlement are fully compensated. The class is fully compensated as a whole. Each class member who puts up their hand and gets their amount of damages is personally fully compensated. And of course, on an individual basis, that might be more or less than they were, so to speak, due in a personal sense. That's the way this collective proceedings works. Subsection 3, where the tribunal makes an award of damages in opt-out proceedings, the tribunal must, and I'd invite the court to underline must make an order providing for the damages to be paid either to the class representative or such other person as the tribunal thinks fit. We can probably skip 4. 5 is critical. Subject to 6, which we'll come to, where the tribunal makes an award of damages in opt-out collective proceedings, any damages not claimed by the represented persons within a specified period must be paid to the charity for the time being prescribed by order made by the Lord Chancellor. Now, this is critical. This is the critical provision. First of all, 5 is expressly subject to 6. And second, and importantly, the combination of the words any damages not claimed with the words must be paid to charity tells you that subject to subsection 6, the only thing that the recipient of the damages sum can do with it is pay represented persons who claim their share and pay monies over to the charity. That's the, in my respectful submission, the necessary and only meaning of 5. Now, 5 is subject to 6, and of course what 6 says is that in a case within subsection 5, the tribunal may order that all or part of what? Any damages not claimed by the represented persons within a specified period is instead, i.e. instead of being paid to the charity, to be paid to the representative in respect of all or part of the costs. Now they are costs, sort of stricto sensu, but also expenses, which would include the funder's fee, incurred by the representative in accordance with the proceedings. So we submit this is a 4-step process. Step 1 the tribunal makes an aggregate damages award. Now, all of this only applies where there's been such an award. That's obviously not controversial. Step 2, once there is an opt-out damages award, the tribunal must order that damages be paid now on behalf of the represented persons in the second and third lines of subsection 3. Now, we have 3 points on that. First, 47C3 is framed as a duty on the tribunal to make the order where the relevant conditions are met. See the word must. Unlike subsection 6, this is not discretionary. It's a requirement. And the must here is equivalent to only. There's only one thing that can be done. If you must do X and you can't do anything else, that's the same as only being able to do X. Second point, the damages award must be paid either to the representative or some other authorised person, for example, a claims administrator. Third, the words on behalf of the represented persons are clearly aimed at transfers to the class representative or someone else to facilitate payment for the benefit of the class. The award is effectively paid to such people on trust for the class to allow it to be distributed. And there's nothing in subsection 3 which allows the award to be paid for the benefit of someone other than the represented persons. And to state the obvious, a payment to the funder can't be characterised as a payment on behalf of the represented persons, as though we're settling some debt that they owe to the funder, not least because in opt-out proceedings, the represented persons have no contractual relationship with the funder. They owe nothing to the funder at all. And that's an important point of difference, as we'll see, between opt-in and opt-out proceedings. And as this is an appeal, even though obviously on the jurisdictional point, it's a point of law, I should identify where we respectfully say the tribunal fell into error. And we say they fell into error in concluding that 47C3B provides an express power to make a payment directly to a funder for their return. That's paragraph 31 of the judgment below. That's at Core Bundle, tab 5, page 84. I don't think we need to turn it up. It's a very short judgment by the CAT. But they gave 2 reasons in support of their conclusion that payments to the funder for its return were permissible prior to distribution. The first was that 47C3B was broad enough to permit payments to third parties such as a funder. And the second was that nothing in the section says that damages can't be paid to the funder, i.e. there's no express prohibition. Now, as to those reasons, in short, as to the first reason, it's simply not the case that you can't pay damages to a third party under 47C3B. You can, but any payment has to be ring-fenced. Whoever the funds are paid to, the monies are on trust of the represented persons. In other words, the monies are transferred through the third party to the represented persons. They're not transferred to the third party for their own benefit. It would also be odd for there to be a must obligation to pay the funder all of the damages.
The subsection doesn't say to be paid, to be held on behalf. It doesn't say that, does it?
No, it says to be...
What's happening on behalf is the payment, not the holding.
Yes, it's to be paid on behalf, but in my
Isn't that because you would normally expect damages to be paid to the recipients, to the represented persons? So the work that the words on behalf of is doing is qualifying the act of payment to the representative, not the terms on which the representative is holding the money.
Well, in my submission, if you pay monies to X on behalf of Y, then what you're doing is, I agree with my lord to this extent, and perhaps entirely, that you're saying, for whether it's for reasons of ease or administration, I can't pay Y, not least because there might be 10,000 Ys, so I'm going to pay X. But X is holding the monies because otherwise you would have paid them to Y. What X is doing is X is now holding them and has received them because otherwise you would have paid all the Ys.
Might it be said that this subsection doesn't say anything about the terms on which the person receiving the money is holding it? It simply requires in fact, is the money is paid to the representative. It isn't saying anything about what terms the representative is holding that money.
In my respectful submission, it does.
You submit it does.
Yeah.
That's what I'm trying to understand.
Because if you pay to X on behalf of Y, then that doesn't allow X to dip into the monies for his own benefit, save in circumstances where, for example, Y has agreed with X that X could do so. That's the point I was just making. There is no contractual nexus here between the represented persons and the funder. So when one looks at 47C3B, and of course one has to look at the whole of 47C. When one looks at that, and then one looks at 5 and 6, in my respectful submission, the inescapable conclusion is that the monies, if paid either to the representative or to some other person, such as the claims administrator, can't then be paid on to the funder. Just to pick up the point I was making as to the tribunal's reasons, and also in answer to my Lord's question, if you must do one thing, as I've said earlier, you can't do something else, and this is a complete code. And of course, the purpose here of this whole section is distribution. The immediate next step is distribution to the class under Rule 93. And the reason why the monies are handed to the class representative or a claims administrator is for the purpose of distribution to the class. Now, we can have a discussion as to whether a trust would or would not be imposed in those circumstances. I don't need a trust, so to speak, to get home. In my respectful submission, I can get home on the words of the statute taken as a whole. The imposition of a trust is not necessary for my submissions. Now, that's step 2. Step 3 is that if there are any unclaimed damages, the undistributed damages, subsection 5 requires by the word must that they be paid to charity. And then step 4 is the exception in subsection 6, which is that where subsection 5 is engaged and there are monies left over, the tribunal may instead order that all or part of the unclaimed damages be paid to the class representative, and that includes both costs and expenses. So in the statutory scheme, in my respectful submission, the only way the class representative can seek expenses, such as a funder's fee, out of unclaimed damages, is under that last section, section 6. And expenses has been held by the Supreme Court to include the funder's fee. I don't anticipate that's controversial. For the court's note, that comes from Packard, as I've said, per Lord Sales in paragraph 98, and that approves the tribunal's 2017 judgment in Merrick's at paragraphs 117 and 127. Now, if Parliament had contemplated that funders or third parties could be paid directly out of damages at step 2, i.e. prior to distribution, then obviously subsection 6 would have been drafted very differently, because it's clear from 6 that an order can only be made to use damages to pay the class representative's expenses where they are not claimed, any damages not claimed by the represented persons. And if the tribunal had complete discretion to order costs or expenses from damages at a pre-distribution stage, the statute would have said that all or part of any damages may be used to meet expenses. It would have been written in a very different way. We submit it's not written that way because that other way would be inconsistent with the policy objectives. So that's a statute. That's obviously very important for my argument.
Your argument is based entirely upon the implication or the inference you draw, in particular from subparagraph 6. There's nothing expressly which says that the fee can't be paid out of damages. You start with there's a duty to pay to the CR.
Yes.
In 3.
Yes.
Unclaimed goes to the charity. there's then a power to pay, the CR can pay expenses out of the unclaimed sum. But there's nothing which says explicitly fees can't be paid out of, out of the damages. You have to infer by extrapolation from 6 that that's the case.
With respect, I wouldn't agree with that, my lord. It's not a question of inference. Once one reads 5, that the unclaimed damages must be paid to the charity, it goes back to my point that if a statute says you must do X, and that's saying you can only do X, and if you can only pay them to the charity, and then 6 is only an exception to 5, it's not, in my respectful submission, it's not an inference. It's the logical consequence of reading the statute and working through the machinery. We may be splitting hairs here in the sense as, of course I accept the statute doesn't say in terms the funder's fee can only be paid from unclaimed damages. If that's a point my lord's putting to me, of course I agree with it. But it's not an inference as sometimes we use that word, where you have to, so to speak, read between the lines. In this case, in my submission, you're reading the lines, you're reading the words. You can only do this, this is an exception, and that's it. Otherwise, there is no statutory ability, there's no ability within the statute to pay the funder earlier.
But it doesn't say all expenses payable directly or indirectly to the funder can only come from unclaimed damages.
It doesn't say that in terms.
So that's what you're effectively, that's your proposition. You are, I think, inferring that from the combination of provisions. It may not matter, but,
Yeah,
but it's a big point to infer when one's looking at what the policy is.
Well, we'll come to policy. I hope not unreasonably cavilling at infer, because infer is where I would submit you deal with A, B and C, and then you say, well, I infer X. Here, in my submission, my proposition derives from, so to speak, crunching through the machinery and seeing what you must do. You must pay it all to the charity. Unclaimed first of all, when you have damages, you've got to pay those damages. Let's take a simple case, to the class representative on behalf of the represented persons. If the class representative gets that money, they can't make a payment to the funder because that payment is clearly not on behalf of the represented persons. So they can't make a payment at that stage. What then happens to the leftover monies? They've got to pay them to the charity, save, at that stage, there's a discretion to pay the funder. Now, on my lord's second
this
point,
argument is predicated, though, isn't it, on going back to the point you made slightly earlier, that the class are not parties to the litigation funding agreement.
Yeah.
But the litigation funder enters the litigation funding agreement on behalf of the class, doesn't he? I mean, he may not have identified the class, but in that the whole sort of commercial purpose of the agreement is he is acting on behalf of the class, and that it's on that basis he enters into it. You no doubt right that they couldn't sue direct, but in relation to whether or not, when he makes a payment to the funder to discharge, for example, a waterfall in Table 1, is he acting on behalf of the class? It'll be said against you, well, he is acting on behalf of the class.
Yeah. Because
his whole sort of raison d'etre is to act on behalf of the class.
Yeah.
So he doesn't, when he pays X out of the damages to the funder in respect of the waterfall, he's not doing it out of the kindness of his own heart or on his own behalf. He's doing it on behalf of the class.
But the class owes no contractual
Well,
obligation.
that's a different issue, though, with respect, Lord Wilson. You may be right, they don't owe a specific contractual duty, but whether he's acting on their behalf is a different question.
But
That's the argument against
yes,
it.
exactly, and I'll come to that when
These
we
are
look
all,
at.
as you rightly said a little while ago, I think this all turns at the end of the day on what the statute means, and it's not perhaps the best drafted of statutes.
Well,
but that would be true of a lot of statutes.
yeah, the parliamentary process, my lords, is often like sausages. What comes out may just be palatable, just about, but you never really want to look too closely at how it's made in the process.
But who are the butchers in this respect? Is it us or you?
You probably,
Yes,
probably
quite.
shouldn't tell us, Lord Wilson.
Yes, well, there were no secrets in this court, my lords.
What about a funding agreement which says that funders will get 50% out of damages, and if and insofar as there is an unclaimed sum, then the CR will apply to the court for the residual 50% to come from the unclaimed sum. Just looking at the word part in subparagraph 6, all or part.
Yes.
Yeah.
So it might reflect an incentivised agreement whereby, you know, you took your chances on how much we're going to be distributed.
Yeah. I certainly would accept this. If I'm wrong on the jurisdictional point, it would certainly be open to a funder, in principle, it seems to me, to say, so to speak, it's not table 1 or table 2, but I'll, so to speak, in my Lord's example, I'll take 50% at table 1, to use a shorthand, and 50% at table 2.
If allowed.
Of course, if allowed. With respect, the words or part doesn't help one get there, because all or part of any damages is instead to be paid reflects the fact that when you have unclaimed damages, that amount may be greater than or less than the funder's fee. In other words, the funder's fee may swallow the whole thing, so there's nothing for the charity or not. So we can't, in my submission, read back from all or part to get to that. But I would accept the point on a different basis, which is it would follow, if I'm wrong on the jurisdictional point, that you wouldn't have to put all your eggs in the pre-distribution basket.
Can I come back to the difference in incentive between table A and table B, and which perhaps reflects the point you're making about parliamentary intent? If you can only recover from unclaimed, a funder is going to look very long and hard at the likely method of distribution if it wins. And I think it's predictable, and we're probably beginning to see this from some of the cases, that some distributions are easier than others. And it might very well be that you would say, actually, we'll take a punt, there's going to be a whopping great big sum which is unclaimed. We just think that's logical. You can't do an account credit, you're never going to find everybody, the sums are too small, and we're going to end up with a pretty large sum unclaimed. Now, you can see that that's why you may have a table 2, which actually reflects only a modest increase in risk over table 1. That's because someone does an ex-ante incentive of likely distributability.
Yes.
Doesn't mean to say that necessarily that's going to be applicable in all cases. And I'm just coming back to the point, funders will take a view, but what about the really deserving consumer protection case for which you're likely to get a high percentage of distribution?
Yeah, exactly. So 2 points on that. First of all, I agree and adopt, so to speak, the first point, because there is a sense from learned friend submission, a sort of an inter rem argument. If I'm right on jurisdiction, this claim is not going to go anywhere, Apple's trying to close it down. Simply isn't the case. This claim we see will be funded at a slightly higher delta. And I respectfully agree with my lord that what this shows is that certainly in this case, and there's no other evidence, in this case, A, it will be funded, and B, the delta is not great. Could there be other cases? The answer is we don't know. I mean, there might be. One can conceive theoretically of such cases. We simply don't know. Now, I will come later to the direct credit point. And can I, so to speak, park that and come to that later? Because it may be that my lord could put the point to me this way and say, imagine a direct credit case. How's that going to be funded? Can I leave that question hanging, so to speak, and come back to that when we look at Le Patoel?
That was exactly the point I was going to put to you.
Oh,
But
good.
you'll come back to it.
Okay.
Good. Well, that's something we can look forward to. Rather more prosaically, could I take the court through the rules? Because I just want to show... Sorry, sorry, my lord.
If you'll forgive me, Lord Wilson. I know you don't like the word inference, so I'm going to think of it as necessary implication, which I think is what you're. As I understand it, your case is about what the necessary implication of this piece of legislation is for what you're allowed to do with the claimed damages part. But the section doesn't actually have any words that say anything about what you're expressly allowed to do with the claimed damages part. Your necessary implication argument is based on reading what it says about the unclaimed damages part and deriving, and I'm trying to put it in your terms, a necessary implication for what it must mean for the claimed damages part. Because your case is that you're not allowed to do this with the money that's in the claimed portion. Is that I'm not trying to be unfair to you, is that a reasonable way of looking at it?
It certainly is with regard to the unclaimed. I mean, one way of looking at this, and I hope this is an answer to my Lord's question. One way of looking at this is to say 5 and 6 are dealing with unclaimed.
Yes.
3 is dealing with claimed. And that brings us back to our discussion earlier about on behalf of. I hope that's an answer to my Lord. So that's why I wouldn't agree that I'm not saying anything about claimed. 3 deals with claimed, which is the exchange we had earlier.
But just following up, I think it comes back to a point my Lord made earlier about the word to in 47C3A. You pay to the representative. You might add in there for its own proper purposes, which would include payment of expenses. It only tells you who where the direction of travel is of the payment, not what happens in the hands of the recipient.
Yeah, I mean the two answers to that are, first of all, the discussion we had earlier, which goes from the on behalf of the represented persons, point 1. Second, if that was the parliamentary intent, in other words, if that was permitted by the statute, 5 and 6 become very difficult to understand in the way they're set out. You end up with a specific carve-out in 6 from the charity in 5, but you've got this, then you really do have a gaping hole, because you've got the ability to pay these expenses, which can be a huge sum, at an earlier stage, and then there really is simply nothing in the statute to justify it or to deal with it.
Unless
So the silence, I didn't mean to speak over my
sorry,
Lord.
unless the CR to whom the payment is made has a funding agreement which says, and this is a matter of contractual choice, either 50% now, 50% out of unclaimed, or even 100% out of unclaimed, in which case you'd need to make provision for that possibility or permutation in subparagraph 6.
Regardless of the split, the jurisdictional point's always going to be the same. Because you can't, in my submission, get round the jurisdictional problem by saying, well, I'll posit a case of 50-50 or 70-30. Because if I'm right, whatever the percentage at stage 1 is going to be, there's going to be no jurisdiction for it. That's why I accepted if
you're right on your analysis, then that's the end
Yes.
of it. I'm just wondering whether if 3 is about the payment, it's the direction of travel for the payment. We don't know what terms the CR has entered into an agreement with the funders on.
Yeah.
It could be 100% out of damages, it could be 50-50, it could be anything.
Yeah.
That might explain why the draftsperson said we at least need to make provision for payment of expenses out of unclaimed, because that's what might be in the original contract.
Yes. In my respectful submission, that it simply isn't, first of all, the way the words ought to be read. Secondly, it is inconsistent, as I'll come to show the court, with the policy underlying all of this, which is it was recognised that there could be a conflict, so to speak, between the funder and the class. And Parliament decided that always, and I underline always, the class wins. I mean, if somebody has to end up here holding the baby, or perhaps part of a baby, it's always the funder. It's always the funder.
I mean, I'd be interested in what your locus classicus for that is.
Yes, we'll look at the consultation, and we'll look at some of the academic articles, and we can also look at the decision of the Supreme Court in Packard.
But if one's just looking at the statute, there's
Yes.
nothing in the statute that supports that submission.
What?
That if there's a conflict, the class always wins.
It,
For the very reason my Lord Justice Birss put to you, that subsection 3 just tells you what the direction of the money is to begin with. It doesn't tell you what the class representative can do with it. And if putting the point against you, as Mr. Baden does, if B covers a funder, well then it's expressly covered anyway. But I think he would also say, even if it's not, this is not saying and the representative must find the people in the class to pay the money to.
But it would be somewhat odd if the person to whom all the damages are being paid for the purpose of the distribution is the funder. But I mean, that isn't going to resolve the point in any event.
That's an extreme example.
Yeah, but
And this is all subject to the supervision of the CAT, isn't it?
yeah, yes, it is.
Again, the statute doesn't say that, but the rules do.
Yes, well, we'll come to the rules. What the statute does is to say the CAT has to pay the award on behalf of the class to either the representative or to the funder. And you don't pay on behalf of somebody by depriving them of monies to which they're otherwise entitled when there's no, when there's no underlying contractual obligation. It does come back to that point. But the second answer to my lord is the point I answered. I think my Lord Justice Green.
The answer to that is in very simple terms. If a class member came along and said, well, why are you paying this money off to the funder rather than to me? You're not paying it on my behalf. The class representative could say, well, I'm doing this because this is the litigation funding agreement that I had to enter into in order to get the funding to run the claim on your behalf. So I am paying this money on your behalf.
And of course, I absolutely see that, but that's why the second part of the answer is critical, because what the very knowledgeable member of the class in this example would say back is, but just a minute, Parliament has said expressly when the funder is to be paid, and has only identified that in subsection 6. I mean, that's why one has to read the whole of this as a whole. And the point I made earlier, that 6 would be drafted radically differently, 5 and 6 would be drafted radically differently if you could pay expenses at an earlier stage. In my respectful submission is a very important point. Now, I was going now to come to the rules. And can I turn first to 93, please, which is at page 910. Now, this rule came into force on the same date as the Act, 1st of October 2015. It's headed Distribution of the Award, and we can sort of read across. Subsection 1 is materially identical to 47C3, except we have a shall instead of a must. Then we have subsection 4, and this is the equivalent of 47C6. The way it's done in the rules is that 6, so to speak, in the Act comes before 5 here. And the key differences are the phrase undistributed damages is used. Undistributed isn't actually defined anywhere, but that is the analogue of damages not claimed in the statute. It adds the practical detail that the tribunal can only make an order where it's notified that there are undistributed damages. And the words costs, fees or disbursements is used instead of costs or expenses. So expenses, the analogue to that is fees or disbursements, and that gives more detail as to expenses. Costs has the same meaning as it does in Rule 104. And then we have subsection 6, which is the equivalent of subsection 5 in the statute, subject to any order made under 4. The tribunal shall order that all or part of any undistributed damages be paid to the charity. And that makes it clear in our submission, like 5 in the statute, that it's subject to the tribunal making any order that unclaimed undistributed damages are to be paid to the class representative with regard to costs or expenses. But we say the effect, unsurprisingly, of Rule 93 is the same as the statute. Unless and until there are undistributed damages, the tribunal has no power to order that the class representative be paid expenses, or here fees and disbursements, in respect of the funder's return. Now, we'll come to the other rules which my learned friend relies on. I'm sorry.
Sorry. Just occurred to me looking at this, might it be said that the reason for these rules, and for that matter actually it applies to the statute as well, because these are, as you pointed out, they're mirroring the statute and sticking with the rules. The reason for having rules about the undistributed material is because you don't have a person to whom the money is going to be distributed to, who could have agreed or accepted that part of it would have gone, for example, somewhere else. You don't have a person, so you need rules. The reason for having explicit rules about what you do with the undistributed thing is because it's undistributed, not because you're saying the only thing you're allowed to do with any of it is to play with the undistributed portion. It's simply because in terms of legislation, you need rules about the undistributed stuff. You don't need rules about the distributed stuff.
I respectfully agree with that to a point. As we'll see from the consultation, you do need rules as to what you're going to do with the balance left over, which is essentially the undistributed. Yes. And there was discussion as to what should happen. What's interesting about it is it's one of those rare cases where the Treasury appears to have lost out, because one of the options was that the Treasury should get their mitts on it. And somewhat remarkably, it was agreed instead that it should go to charity. But the central submission I make in my reciprocal submission is still good, because it's only at that stage where you have the undistributed, where the policy is it'll go to charity, but effectively in competition with the charity and at the CAT's discretion as to whether it should get it in priority to the charity. At that stage, the funder can be paid. But it does bring us back to the underlying question, is that the only stage or not? Which is really the pivot here of the entire argument.
Yeah.
I mean, some people were arguing, they were arguing CPRE, they were arguing for the Treasury, they were arguing from some other fund. There was a big discussion. And in the end,
It occurred at about the same time, I don't know if you remember, there was a big hoo-ha over price fixing by private schools. And the Office of Fair Trading, as it was at the time, decided that the penalty would be paid to charity rather than into the consolidated fund.
Right.
And I think that was the vogue at the time. I think that had quite an effect upon the provisions under the Consumer Protection Act.
yes, and just to take the point of a stage further, of course, we've also gone on to say that in cases where somebody acting pro bono gets a cost order, the costs also go, I think it's actually to the same charity, I think. The Access to Justice charity.
It is, yes.
It's the Justice Foundation, isn't it?
Exactly.
It is Justice
Access Foundation. Now, as I say, I'll come to the other rules shortly that my learned friend relies on, but obviously our main submission is any rules can't go beyond the statutes, and I'm sure that is common ground. Now,
the regulations were adopted by statutory instrument to implement Section 47C under the Consumer Protection Act, so plainly they can't.
Precisely. Now, just to show the court the CAT guide, just to round this off, we can pick it up, it's at the next tab, 24, we can pick it up at 921, there's a heading, distribution of damages at the top of the page. I'm not going to read it out, just to identify the relevant paragraphs. 682 sets out what will happen immediately after an award of damages. The tribunal will give directions as to how the class member's entitlement is to be calculated. The first two sentences of 684 are important. In most cases, the tribunal will order they be paid to the class representative so that the representative manages the distribution to the class or the represented persons. In opt-out, tribunals required to order the damages be paid to the class rep or another person tribunal thinks fit. That's the point I was submitting. 687, undistributed damages, i.e. first sentence which have not been claimed. The class representative is required to notify the tribunal if there are any. And if we pick it up over the page, once an amount, second line, has been ascertained or largely ascertained, the tribunal may order be used in the following ways. And we see bullet point 1 is essentially funder's fee, etc. And bullet point 2 is the charity. And then 689, the default position is that it's paid to the charity. That's the effect of 5, to which 6 is an exception. And then third line, where the class representative seeks an order that the undistributed damages be used instead to cover all or parts of its costs, fees and disbursements, the class representative must make an application to the tribunal. And that's the application under 47C6. And the last sentence there, obviously the class representative will only be able to make such a claim out of the undistributed damages insofar as it's not recovered its costs from the defendant. And then 690, last sentence, the Access to Justice Foundation can be heard on that application, essentially because it's a battle, so to speak, between the charity and the funder, and you've got to give the charity notice of the application under Rule 93. Now, we submit, therefore, that not only do the Act, the rules and the guide not permit what sought to be done here under Table 1, we do submit they don't even contemplate an application of the kind in the LFA here prior to distribution. There's no procedure for it, there's no basis for the class to be heard, and indeed you do have the rather odd position that certainly so far as Mr. Gutmann is concerned, on this application, he would be advocating for the funder to be paid in priority to the class, and in circumstances where there may not be enough money to go around, you do have the situation that he's saying we'll pay the funder even if that means that some of the class will lose out at the end. And we do submit that that is wrong in principle. And
Well, it doesn't know. I mean, in a sense, you could say this is all premature. Because it's all under the supervision of the CAT, and in due course, when there isn't as it were, a lump sum of damages, aggregate damages, the CAT will decide what to do with it. And if, for example, it's not as much money as people might otherwise have hoped, the CAT might say, well, only 20% should go to the funder. It's distinctly possible.
I accept that when it comes to an application under 6, the CAT has a discretion. But my submission is that there's a hard-edged jurisdictional question as to whether, in principle, as a matter of jurisdiction, you can pay early. Yeah. But obviously, I mean, it's premature in the sense that we're arguing about it now. But the jurisdictional point will be the same now and the same in however many years' time.
But I mean, it's interesting that, I mean, I said a moment ago, it's not the world's most best worded statute. But I mean, in one sense, if you're right that the funders can only be paid out of the undistributed damages, one might have thought actually that the statute would be worded differently, in a different way from the way you're suggesting, which is that 5 and 6 would be worded completely differently, and that the default position, which would be subsection 5, would be the money's paid to the funder, and only when the funder is satisfied does it get paid to the charity, which is actually, on your case, that would be the commercial reality of what happens in every single case, because everybody knows, and it must have been contemplated by Parliament, that these collective proceedings were going to be funded.
Well, yes. I mean, what's interesting, if I may say, about that is that, as I showed the court earlier, there is a reversal between the Act and the rules.
Yeah, well, I follow that.
And the rules adopt what I respectfully agree with my lord is, so to speak, the sort of the commercial reality of the position.
Yeah.
What is interesting is that when one goes back to the parliamentary debates, and we have gone through them, we're not presenting them to the court because we're not running a pepper and heart type argument. It does appear actually that the position of what happens to the funder wasn't necessarily at the forefront of everybody's mind. They knew there was going to be a funder. We have to read in, so to speak, into expenses the funder's fee. The fact that the fact that the Act has 5 and then 6 is because of the consultation, in my respectful submission, because the focus was what, my Lord Justice Birss question, the focus was what do we do with the remnant? What do we do with the remainder? Answer, it goes to charity. Oh, just a minute, what about if there's somebody else? Oh, we'll make it subject to that. I mean, that seems to be the genesis, but it's interesting that the rules flip it.
I'm not certain that that's quite follows. What if subparagraph 6 of 47C didn't exist at all? So there was nothing about recovery of expenses out of unclaimed distribution. Would you say that there was no provision for funding of the funders at all?
Yes, that must be the consequence of my argument. And indeed...
And then that really depends upon Lord Justice Birss's point about the meaning of the word to in subparagraph 3.
Yeah. And
whether one inserts the words, paid to the class representative brackets for its own purposes, end brackets.
Yes, except. Can I answer the question in two stages? As I said a moment ago, there would be nothing express in my submission allowing the funder to be paid at an earlier stage. In my Lord's example, if 6 wasn't there, that has to run from my argument. I can see the following argument, second part of my answer. I could see the following argument in those circumstances. There was always obviously going to be funding. It can't make sense that Parliament hasn't provided for any way for the funder to be paid. The funder's got to be paid at some point. The only words we can hang that hat on, so to speak, are the words in 3 and the 2. And therefore, we're going to read that, essentially the point my Lord Justice Birss put to me. I can see that argument, but, and this is the point I sought to make earlier, I hope I'm not repeating it unnecessarily, but since the question may have been repeated, let me repeat the answer. In a case where Parliament has specifically turned its mind to where the funder is to be paid from in 6, that is an additional reason not to read the 2 in 3 in this very expansive way. It's one thing to say Parliament can't possibly have contemplated a jurisdiction where funding is needed and yet there's no way to pay the funder. We're going to have to find, so to speak, by, if I can say respectfully, judicial hook or crook, some way to get the funder paid. Otherwise the whole thing won't work. I could just about see that.
Then they just assume it's all part of the class representative's task, who will represent the class, act for or negotiate with the funder. So if I give the money to you, Lord Wilson, as the CR, you just do with it what you have agreed to do with it, with those behind you. Does Parliament need to grapple with that?
In circumstances where Parliament had not provided in 6, as I say, for payment of the funder's fee by way of expenses, one could see that argument. But the problem, in my submission, with running it in a case where, as here, Parliament has turned its mind in 6 to when the funder gets its return, is that we're saying, well, Parliament said, in terms, the funder gets its return at the end. And as we'll see, that's because of a policy decision, that's, if somebody is end up holding the baby, it's going to be the funder. It's then quite a leap, and in my submission, an impermissible leap, to read 3 in what I do submit is a very contorted way, in a wrong way, to try and find a way to allow funding at an earlier stage. It would be a very different statute if 6 wasn't there. The court will be looking at it in a different way. But 6 is there. And my submission is that when you go through the sequential steps, as I've sought to do, the only place where the funder's return can be paid is 6. And it was, as we saw from the rules and also from the guide, it was never contemplated that the award would be used to pay anyone other than the class. There's no provision or guidance or rule for that or for any such application. Or for members of the class to be heard on it in circumstances where, as here, the class representative has taken the position of the funders on that point. So let me come to the policy, because we've touched on that a couple of...
You took us to the rules. I was just wondering about 94.8 and 9, and the way in which they're structured. This is the approval by the tribunal of a collective settlement.
Yes.
And the tribunal applies an overarching test of what's just and reasonable.
Yes.
And in determining justice and reasonableness, the tribunal takes account of A, amount in terms of settlement, including provisions, costs, fees and disbursements.
Yes.
That's separate. And well, separate from G.
And also G, yes, exactly.
But it's separate from it.
Yes.
So
Yes.
it rather suggests that it takes into account the general provision, but it also says, quite separately, what do we do about unclaimed balance? So we dealt with costs and expenses, disbursements. We're now looking at the unclaimed bit.
Yes.
So it suggests it's separate from unclaimed.
Yeah. This is in the context of settlements.
Settlement, well, approval of the collective settlement.
Approval of collective settlement. Now, I'll come, if I may, to collective settlements, but my short submission on that is that it's totally different. I mean, it's totally different. I mean, just to sketch out the answer, we'll come to this a little later, because the point my learned friend relies on. In a settlement case, we don't even know whether there's been an infringement.
So
We
you don't
don't-
know what,
Whether there's been an infringement. We don't know whether the claim was actually good, bad or indifferent. In short, we're not dealing with damages. The sum of money in a settlement is not damages. It's a sum of money which is being settled, paid to settle a claim. The claim may have succeeded, it may not have succeeded. The claim may have been good, it may have been bad.
How should the funder be in a better position of a settlement than in relation to a claim for damages?
Let's start off, I will answer that question, but let's start off just because, first of all, the first part is, as we're looking at the rules, the tribunal is doing a different thing. The tribunal, to continue my last point, and it will answer my Lord's question, I'm not dodging it. The tribunal is doing a different thing. It's in a damages case, the statute has said, if you have an award of damages, you must do this with it. In a settlement case, the tribunal is standing back and saying, this claim was brought, this is the proposed settlement, are we going to, can I use the word bless it, approve it? Now, that might mean that the funder, so to speak, gets more or gets less. The funder, the tribunal has a broader jurisdiction in settlement cases, and insofar as that means that the funder can obtain sums, so to speak, at an earlier stage, yes, that may be a consequence of it. But in my submission, the point goes the other way. If it was intended that the tribunal would have that sort of general discretion, roving brief in the damages case, one would expect that both the Act and the rules would say so. Settlements are different. Settlements are different, not least because we are not dealing with damages. The way this works is that damages are full compensation for the class. And what Parliament has said is the primary aim is to get as much of that out to the members of the class. That's why the money is paid over to the class representative. That's why you see the phrase for the benefit of the class. Once that's done, then we have the question: where does the residue go? Charity or funder? But the collective settlement, the siren call of the collective settlement is to be resisted, because that's a different area.
Applying your policy imperative, funders are at lower risk on a settlement, and that increases the incentive on them, and we've seen this from the Canadian literature, claim long, settle low. And that's rather adverse to the policy that you've been advocating, if you're right.
Well, there's obviously a balance, isn't there? Because if you try to settle, so to speak, too low, the settlement won't be blessed. I mean, there were conflicting policy imperatives here. On the one hand, you want the class to get as much as you can. On the other hand, a settlement is the proverbial bird in the hand, as opposed to, two birds in the bush. So, all of this needs to be balanced, because in a settlement, the money's here today. Who knows how long litigation will last? It goes on appeal to this court and then maybe further. So all of these issues would be balanced in the settlement. So the fact that it may be in the funder's interest, so to speak, to settle early, it doesn't necessarily mean it's not in the class member's interest to settle early. But what we do know is, once there is an award of damages, because once the court has said this amount of $1 million, but whatever the figure is there for the class members, in full compensation for the class members, then it is adverse to their interest for somebody else to be dipping in first. Now, I was going to take the court to the consultation briefly, which I appreciate certainly some members of the court will have seen before. And I was going to jump to the government's response, which is at tab 26. 26.
Yeah.
And if we go to page 999 at the top of the page, introduce a limited opt-out collective actions regime with safeguards for competition law. And if the court could just read to themselves the first two paragraphs, you'll see obtain redress for their losses and then get back the money that's rightfully theirs. And those are the principal aims. Sorry, the first paragraph on 999 will allow consumers and businesses
Oh, yeah.
elected
Gotcha.
obtain redress for their losses, and then in the next paragraph, 3 lines up from the end, get back the money that's rightfully theirs. And just for my Lord's notes, there are other paragraphs which say substantially the same thing. I'll just give the references 5.28 and 6.26.
I'm sorry, Lord Wilson, that's probably B, but where does it say get back the money that's right?
The second paragraph on 999,
Sentence starting.
there's 3 lines up from the end of that paragraph.
Oh, gotcha, yeah, okay.
And then if we could turn to so the other paragraphs, as I said, are 528 and 626. We don't need to look at that. But then at 546 of this document, which is at page 1031 of the bundle, there's a heading, unclaimed sums. And this comes back to the point that my Lord Justice Birss put to me. And there's a discussion here as to what should happen with the money. And just glancing through, you'll see there are different options, including in 549, reversion to the defendant. And if we scroll through, the discussion is picked up at 1034, at paragraph 5.64. And only a small number of people argued in favour of CPRE. Government's position, preferable to have a named recipient, whether that be the Treasury, the defendant, the charity, or some other charity. And the conclusion is at 570, further down on that page. And what's interesting about 570 is not only that the Access to Justice Foundation wins out, but importantly, though leaving defendants free to settle on other bases, this is only dealing with damages. And you can do anything else in a settlement case. Indeed, in a settlement case, you can have reversion to the defendant. In a settlement case, the tribunal could approve that if that was appropriate on the particular facts. So, and then you have the separate paragraph on settlement 572, providing that it needs to be judicially approved, and also claimants being given an opportunity to opt out of the settlement. So we submit 2 things become clear. First, it's clear that the government considered that there would be unclaimed sums and that they should go to charity. So 100% take-up wasn't envisaged. And secondly, the government didn't consider here the funder's return in terms, certainly wasn't focusing on cases with a high take-up. Rather, compensation to class members was the principal aim behind the regime. And we submit there's nothing at all here supportive of the class representatives' position. Now, as to my point as to low take-up, in my submission, this is an accepted reality of the regime. It's well recognised by the tribunal when considering distribution. We'll come to account credits a little later, but just to show the court a couple of points on this. In the recent decision in McLaren, for example, which is in the authorities bundle at tab 21, which is at bundle 3. And I'm just picking this up. This is a decision from January this year. At paragraph 86, which is at page 894 of the bundle. The court will see the last 2 sentences of 86. And in addition to this, Mr. Gutmann himself, wearing a different hat, this time he's not on his phone, but he's on a train, is very aware of these low take-ups. In the settlement judgment of the tribunal in Gutmann trains, Mr. Gutmann, in fact, relied on low take-up rates when seeking approval of the settlement in that case. And it's conveniently in the same bundle behind tab 18. Again, we can take this quickly. It's on page 775, paragraphs 89 and 90. In 89, second sentence, you'll see that Mr. Gutmann gave the range of 10 to 20% take-up based on North American experience. Tribunal goes on to say no one knows for sure what it's likely to be. And then in 90, the Tribunal refers to a document from the Federal Trade Commission which suggests it could be lower than 10%, perhaps even down to 4%. But we needn't spend too much time on whether it's 4, 10 or 20. The point is that built into the regime is the supposition, the proposition, that take-up is going to be low. And that explains why Parliament said, well, in which case the funder can get its return from unclaimed damages, subject only to a battle with the charity. And the Supreme Court in Merrick's recognised that this is a key feature of the regime, the aggregate damages approach. Again, the court will be familiar with this, but let me just show the court it quickly. It's at bundle 1 of the authorities, tab 6. And it's picking it up at page 197 of the bundle. In the judgment of Lord Briggs, the bottom of the page, paragraph 3, Lord Briggs identifies 3 key features. The second over the page between A and B is aggregate damages, which provide just compensation for the loss suffered by the claimant class as a whole. And then in between B and C, the third feature was distribution to class members, and then noting any unclaimed residue of an aggregate award of damages is to be given to ... charity specified by the Lord Chancellor, or used to meet the litigation costs and expenses of the representative. Now, I'm not saying, of course, that Lord Briggs was focusing on this point, but certainly that is his understanding of the way the regime works. And while we have it open, if we could just turn through, please, to page 211, and the bottom of the page there at 45, could the court just read to itself, please, paragraph 45 from that judgment? And if the court has read 45, I was going to take the court to 58 on page 216, which again notes the importance of the compensatory principle when assessing damages and the background of the statutory regime. And of course, the whole point, this is the point made in 58, is that all of this is done on an aggregate basis. That's the nature of this jurisdiction. To pick up the same points as were in the case from the judgment of Lord Sales and Lord Leggett, which is at 236, heading before 148 on page 236, the distribution issue. It's the first bit of 149. We think it's clear that under the legislative scheme, where an aggregate award of damages is made, the award is the means by which compensation is achieved. That's to say, by providing compensation for loss suffered by the class of represented persons as a whole. So looking at what happens, therefore, in non-collective proceedings or individual proceedings isn't instructive. And I say that because the learned friend makes some comparisons, whether it's liens or funders' fees in private litigation or some such. I mean, all of that really is beside the point. This is a different regime. It's a unique regime. And the question is, how are damages to be calculated, paid and distributed in the opt-out collective regime? And that's the background to section 47C. Now, we set out in our and yes. Sorry, I'm sorry, my lord. I'm just. Oh yes. One of the I was going to take this point later, but let me take it now. One of the pointers we saw is that the Act, the rules, and the guide provide what we've called guide rails for the exercise of discretion of any significance which relates to this regime. For example, when it comes to the authorisation condition, when it comes to the eligibility condition at the certification stage, or in relations to settlements, the tribunal is told the factors which they have to bear in mind. Now, we submit that it would be remarkable if the rules were to be construed as giving the tribunal a discretion as broad as the one and as fundamental as the one which we're debating today, without any guardrails to assist it. And I say fundamental because this isn't a case, this wouldn't be a case management decision. I mean, this is a decision we're talking about when damages have been awarded and where the damages belong to the class. Class members want to collect, but the tribunal would be saying no. At least in the first instance, we're going to turn you away and we're going to hand your money to the funder first. And that would be, we submit, an extraordinary power to bury in unrelated case management directions with no guidance as to how to weigh the interests of the funder against the interests of the class. And it's helpful to take the point now because as we're in Merrick's, if we go back to Lord Briggs's judgment at paragraph 27, he makes the point at 27, Rule 75 to 81 make detailed provision for commencement and certification of collective proceedings. He goes on to consider Rule 79 about eligibility. And we can see here, this isn't in the bundle, but 79 2 to 3 set out in terms the way, and it's on page 205, set out the factors which the tribunal would have to consider. And the same point is made at paragraph 111 per Lord Sales and Lord Legate, which is on page 229. That again, to use their language, it focuses on what they call the substantive rather than a merely checking box for the cat in making the relevant judgment whether the claims are suitable to be brought in collective proceedings, the wide frame of reference to be adopted, and providing a non-exhaustive list of matters which the cat might think fit to consider and place weight upon. And then obviously Rule 78 1 to 3 have detailed factors regarding the authorisation condition. And in those circumstances, the notion that some, so to speak, broad, unrelated provision in the rules could be used as a hook for this fundamental point, we submit is inconsistent both with the statutory scheme and also with the fact that the rules elsewhere, when there's a big decision to be taken, go into detail as to the factors which the cat has to bear in mind. Here, it would be absolutely a cat's general discretion, which isn't the approach of the rules elsewhere.
Do we need to take account of the combined effect of rules 2 and 4? I don't think we've got them here. Rule 2 says that every rule shall be, which includes 77, shall be construed in the light of the overarching guidance principles in Rule 4, which has express provisions on ensuring proportionality and justice and fairness in relation to costs.
Yes.
So they do have a very broad overarching power which would apply in relation to Rule 77 to ensure that anything in relation to costs is fair, proportionate and meets the principle of justice.
That, in my submission, that's not a power. they have to bear that in mind all the time to be proportionate and fair and just. But it's not a so to speak an originating jurisdiction. It's not a separate font of jurisdiction. I absolutely accept that when you're reading the rules, you read them with that in mind. In the same way, when you read the CPR, you read it in the context of the overriding objective. But you still have to find the basis of the jurisdiction, because otherwise you're going backwards. Otherwise, you're really using a bootstraps argument to say because you need to bear in mind justice, therefore you can do anything which you think is just. That's not the way jurisdiction works.
So I think Rule 2 says all rules must be construed in accordance with Rule 4, and I think Rule 4 says, and I don't have it here, but I mean, I think it's a broad power to do everything in accordance with justice, fairness, proportionality, which is supplemental to principles of interpretation.
Yeah, and I think that's why I was accepting, or at least accepting sort of for the purposes of argument, that if we didn't have 6, I could then begin to see the argument, perhaps using this as part of the argument, to say, because there's going to be funding, and because I've got to make this jurisdiction work, and look at Rule 2 and look at Rule 4, I'm going to read 47C3 expansively, because otherwise I've got nothing else to do. I've got no options. In other words, that's my only route if there's no 6. But I do say, in a case where you've got 6, you can't do that with respect. I'll try to stop saying with respect. Take it as read. You can't do
with
that.
disrespect.
Never, my lord. You can't.
We know what
hoist by your own petard then.
when counsel says with respect, we absolutely understand what it means. I mean, shut up and listen. You got it entirely wrong.
Yeah, certainly not. Certainly not. The situation would be very different if there wasn't 6. Because, and it's at that point where that sort of argument could be used. Say, well, yes, of course I'm stretching 3, but unless I do this, what else? I've got a jurisdiction which can't work and won't work. That isn't this case. The jurisdiction can work. This case can work, we see, Table 2. And Parliament has provided for where it gets funded from C6. That's the shape of the argument. Yeah. Now, we've set out some of this in our written argument at paragraph 23, where we've put in a quote, which I don't know whether the court has the written arguments on paper, or whether they're in the core bundle for the court. So in the core bundle, it's on page 23 as well. And the reason I just want to remind the court of that is that we set out a quote there from Jenny Wilmot MP, who was then the Parliamentary Under Secretary of State, and the court will see what we've underlined there. But the same rationale is reflected in the obiter comments of the Supreme Court in Merrick's, which we've just been to. I'll just show you that, and also in Packard. But let me just perhaps show you Packard quickly on this point, which is at tab 13, which is in bundle 2 of the authorities. And it's at tab 13, it's at page 567. And this is the paragraph 98, which I'd mentioned a couple of times earlier, and I said I'd take the court to. And again, if I so to speak, can speak while the court glances through it, the court will see that Lord Sale says in terms that the funder of opt-out proceedings always takes the risk. Now, what risk? That all of the damages recovered will be distributed to members of the class with the result that there will be nothing left to pay its fee, and also takes the risk that the tribunal might decline to exercise its discretion to order a payment in favour of the funder. Now, note in my submission the 2 risks. The first, the funder always takes the risk, not the class. That's, in my submission, the balance struck by the Act. And the second risk is the risk to the reference that the tribunal might not exercise its discretion under subsection 6. Now, with regard to that first risk, that there might be nothing left over, as I've said, the opt-out proceedings are premised on the idea that there would be limited take-up, plainly less than 100%. That was based on experience and learning some other collective regimes. And that's why the balance has been struck in the way it has. Now, this approach, which I am seeking to persuade the court of today, is supported by academic commentary from Professor Mulheron. And I don't know whether the court's had the opportunity to look at this article before.
In the past we have.
In the past.
She's now a member of the CAT, isn't she?
Exactly, and I was going to make that point. It was written obviously before she was appointed an ordinary member of the CAT. And to be very clear, this court will know her stellar CV in this area. This is written in a personal capacity, just to make the proper point.
So which page are you taking us to now?
So I was going to take the court to, this is authorities bundle page tab 27.
Yeah.
And we can pick it up at 1070, please.
Just before we do that, I'm just looking at Jenny Walmott's observation in the Bill Committee. She says one option.
Yes.
She doesn't say that was necessarily the option chosen or selected. She just identifies that as one option, and you're saying that necessarily implies that was the option selected.
Well, it's certainly consistent with the option which is selected.
It's consistent with your interpretation.
Yes.
Can I ask you then, section 47C doesn't say when the money is handed to the class representative, they cannot pay any sum of money to the funders, even if this places them in breach of their contractual obligations.
Yes, it doesn't say that. I mean, the consequence.
You might say that, in a sense, the corollary to 6 is, you'd have needed to say that because without an express prohibition of paying it out of damages, don't you need to say almost the opposite? The class rep cannot comply with its contractual obligations once we've handed the money to it.
No, because that really is a bootstraps argument. Because if I'm right that there's no jurisdiction to pay.
If you're right, you're right.
Yes. But if I'm right,
construe 6 in the light of 3.
Yes, but if I'm right, then the class representative should not be entering into any such contractual obligation which requires them to do something for which there's no jurisdiction, and therefore the statute wouldn't deal with it because it wouldn't be available.
No, but there's a lot of things which are not said in this statute, and we're having to fill a lot of gaps here. If you're right, then you clearly, that's the ex ante obligation, you comply with it. If you don't comply with it, your contract is a breach of statute and is void.
I absolutely accept the point that sometimes in this area the court has had to fill in the gaps. And we've all read the judgments. That's why I hope realistically accepting that if 6 wasn't there, you could see a court, so to speak, rolling up its sleeves and saying, right, somebody has to rescue this jurisdiction, and if it's not us, then who? And that's what this court would have to do.
You can equally see someone saying, okay, you've got your basic contractual obligation which is protected under 3, and then some bright spark saying, what happens, can they recover from unclaimed? Oh, we better make sure that that's covered. Subject to supervision by the CAT, yes, they can cover from either claimed or unclaimed.
Well, we're going over the same ground, but the problem there is, as I say, that 6 will be written in a very different way. What is the application? Where is the application under 3? Who's heard on it? How do I mean? There's a lot to build in there. But I think what some of these interchanges show is that when you have a hard-edged jurisdictional question like this, so to speak, everything flows from that pivot point, and you come at it from all sorts of different ways, but ultimately you get back to the question, what does the statute say and provide?
Are you going to take us to Professor Mulheron's?
Yes, I was. Can we start at 1070, please? So, I'm not sure what the interference is.
Well, it's going to be one of those microphones.
Oh.
I don't know if can you remember which one it is?
It's the lead going into my mic. Thank you.
We'll just take it out.
Okay. I've been disconnected.
Don't worry, you can still hear you.
With respect.
Oh yes, just to pick up, Malone Judy points out, just to pick up my Lord Justice Green's point on Jenny Wilmot's point, just to give you the reference, she does say the amendment will mean that. So it's not just, certainly she thinks that's what the amendment means. Yeah.
How much do
1070.
you get from that, really? Yeah, okay.
It's not the central point. What 1070, Roman 3, legally establishing the funder's right to recovery. And we do ask the court to read through this article. We've highlighted the various bits. I'll do it relatively quickly now. But she identifies what she calls the dilemma of a funder in opt-out proceedings when it hasn't obtained any explicit permission from absent class members to take a portion of each class member's damages. And she notes the representative claimant receives the aggregate sum on behalf of the entire and undefined class. That's 2/3 of the way down that passage. And at the end, the representative cannot just give away a portion of each class member's damage to a third party, such as a funder, without a pre-established legal right to do so. Now, that means a legal right, not an obligation that it may have taken on. It's got to have a right to do it. And moving on to 1082, under the heading 5, the UK response to the conundrum.
Just a minute, Mr. Wilson, you skipped over that. Isn't in this article, isn't the legal right referred to? One possibility for it is the contract that's referred to in the next sentence.
Yes, the vexing problem of recovering fees in the absence of any contractual relations has been well identified.
Exactly. So that's the distinction between the recovered damages and the unrecovered damages. The contract here we're talking about is the absence of a contract between the funder and the class. Right.
And so what you're saying at the end of the previous paragraph is, what is the legal, since the damages have been paid to the class representative, where is the legal right for the class representative to pay it to the funder, which is the point we've been looking at. And she's saying, because there isn't a contract between the funder and the class, you can't, the class representative can't say, well, I'll pay it to the funder, and in doing so, I'm discharging the contractual obligations of the class to the funder. There are no such contractual obligations.
No.
That's the point she's making.
Yes.
Then I was going to 1082. She sets out there a number of options. One option was to give the funder a statutory entitlement to draw on the damages award as a charge. That didn't happen. And she notes 3 difficulties with the funder having what she calls a first charge over the damages award. You'll see towards the bottom of the page, first, English policymakers didn't like US-style class actions and a litigation culture. And a first charge, precluding a first charge, would avoid that. Second, the compensatory principle underpins the regimes. The primary beneficiaries are the aggrieved parties for whose benefit the action was brought. And you'll see that footnote 111 refers back to the consultation which we just looked at. And then the paragraph beginning, and then the third point is that if the funder could be paid a CFA success fee and ATE premium would be in the same position. Now, if we look at the paragraph beginning hence, and if the court could just read that through. She concludes at the end of that paragraph at the top of 1084, were the CAT not to have made an order for the payment of the representative costs and expenses incurred, then the unclaimed sum in its entirety would be paid to the charity. Now, then halfway down the page, she describes the introduction of section 47 C6. And the point in the middle of the page is a point which has been put to me by my Lord Justice Green. One of the consequences would be that for a case in which a Class 1, it would be inimical to the funder's interest for all the class members to come forward to claim, for that would dwindle the unclaimed damages sum to which the funder's second charge applies. In response to that, 3 points should be made. And then the second point is interesting in that context. Where the class members' individual entitlements were sufficiently sizable to tempt large numbers of them to come forward, the risk of the funder not being paid would increase, but under the proposed regime, the CAP must take into account the estimated amount of damage that individual class members may recover when determining whether it should proceed as an opt-in. And if it went to opt-in rather than opt-out, then the funder couldn't recover its success fee as a second charge because 47C5 and 6 limit it to opt-out. But in that case, you would have a funder entering into separate LFAs with class members under a tied class arrangement to secure a contractual entitlement to its success fee. So in that case, the way to do it would be to have an opt-in and to have a contractual relationship between the opt-in members and the class. But then thirdly, when balancing the conflicting policy viewpoints, the government's view was clearly in favour of the former. I'm reading on page 1085. It would follow claiming class members would not forego any of their damages recovery to pay for the funder's success fee. The funder couldn't take a percentage fee from each class member's damages. It wouldn't have a contract with them. It's got to claim its success fee from the unclaimed pot. And then she makes a point of distinguishing the position from the US class action. And she concludes that the compromise, and it is a balance, it's a policy balance, which 6 represents the tangible demonstration of the full compensation principle that the government placed at the forefront of these reforms. It distinguishes it from US-style class actions. It's also likely that given the anticipated take-up rates, funders would ultimately receive due recompense for facilitating access to justice by virtue of the second charge created by that provision. And having got to the end of 1085, can I just go back? I think I skipped over a point I was going to show the court on 1084. If we go back to 1084, 2/3 of the way up the page, there's a paragraph which begins by contrast, and this goes back to the exchange we had earlier. Insofar as settlements are concerned, there's no equivalent provision to 47C6. It's anticipated where settlements are concerned, the funder's fee will be paid separately to the damages. The various fee agreements that will be part of the overall settlement terms must be approved by the CAT as being just and reasonable. And that is, as I said, the point, that is why my learned friend's point about full compensation is a misreading of the article. The idea of full compensation is in respect of the class as a whole gets the aggregate damages award, and each class member who comes forward gets full compensation on the basis that their individual amount is treated as full redress for them. There's full redress on a collective basis, and for those who receive the money, it's full redress for them. And that's the nature of full compensation in the collective regime. And so given that, and given the anticipated relatively low take-up rates, Parliament's intention was class members first, funder second. And that is the compromise, to use the learned professor's word, which 47C6 represents. Now, I was going to go to the article relied on by my learned friend, but perhaps I might do that in reply. just really sort of 2 points on that. First of all, when one actually goes through this is the article at 28. It's relatively short. It actually confirms that our approach, what we submit, is actually a widely held view in the market at the moment, and there is also this Cassandra-like submission, although I bear in mind that Cassandra was actually right. The Cassandra-like submission, this was put to me once by Vice Chancellor Scott, that one of my submissions was a Cassandra-like submission, and he ruled against me. I was too junior and not brave enough to point out that the whole point about Cassandra was that she was right. And that probably would have been a career-ending move. But this is an inter aurem argument in this article, that if we don't have funders being paid at an earlier stage, there won't be any funding. But there's no evidence for that in this case, frankly, or at all. And indeed, this case that I've shown shows that there will be funding. The only other point about this article, which my learned friend may deal with, is the interesting comments of the reviewer, the peer reviewer at page 1112, who takes rather a dismissive view of the whole article. But I'll come back to that in reply if I need to. Now, what I was now going to do was to come to some of the cases. I've said that obiter, but obviously Le Paturel is somewhat the authority in the corner here. So let's look at it. So Melinda Junior asked me, I wasn't sure whether the court was going to take a transcript break or not.
Well, we've rather gone past it, haven't we?
Yeah, I wasn't sure, but
Yeah, well, I think if the transcript is being dealt with remotely, then it's up to the transcribers to make their own arrangements remotely.
I'm grateful. So let me take the court, please, to Le Paturel, which is at authorities 10.
Yeah.
10, my lord. And now, my learned friend says that the jurisdiction to make an order to pay the funder from the award of damages before distribution was approved in this case. And my respectful submission, it wasn't. No such order, of course, was in fact made in this case, because no damages were ever awarded in this case. And as I indicated earlier, so far as we can see from the report, the court didn't hear argument on this jurisdiction point. And third, again, as touched on earlier, really this case is about the innovative method of distribution by way of account credits. And even if I accept, for the purposes of argument in this court today, that such innovative methods are in principle available, that tells us nothing, in my submission, about the construction of 47C6. At most, it identifies a class of case in which a large proportion of damages might end up being distributed to the class if the tribunal chose to adopt that method of distribution. So turning through the judgment, we can start, I think, at paragraph 28, which is on page 357. And Lord Justice Green refers to the comments of Lord Sales and Lord Leggett, which we've already seen, about access to legal redress and the principal object of the collective action regime to facilitate access to justice. At 30, just above F, the previous regime was ineffective at improving consumer redress. And over the page at 358, at the bottom of the page where the marker is, there's a reference to 47C3 and notes that where damages are awarded, it must be paid to the representative or the third party. By D on that page, the court recognises that the Act doesn't indicate how the damages are thereafter, in practical terms, to be distributed to the class. And of course, that's what I say it's been paid for. It's been paid for the purposes of distribution, not to pay anybody else. 34 refers to 47C 5 to 9, the position where there are unallocated funds after distribution. 35 refers to the rules. And then turning through to paragraph 41 on page 362, notes Rule 93 addresses distribution of an award of damages, but caters for the start of the process and one eventuality in between that might arise at the end, but otherwise is silent as to how it's to be distributed, leaving it to the broad discretion of the CAT. Then 42 notes that Rule 93 1 and 2 addresses the start of the distribution process, replicates the effect of the statute. We've looked at that. And of course, we accept the tribunal has the ability to give effect to the distribution to the class. Practically speaking, it's a class representative which carries out that process, which the CAT approves. But any discretion, and this is the important point, any discretion which the tribunal may have can't override the statutory duty it's under to order that the award be paid to the representative on behalf of the class. And that goes back to the discussions we had earlier. 43 in the judgment refers to the default position, which we've talked about. 44, the court notes the discretion the tribunal has with respect to making case management decisions and refers to a broad power in 93.3 to control the distribution, i.e. that's distribution we submit to the class. That's what this case was about. 45, again, broad power to make case management decisions, but that's Rule 88.1 is one of the rules relied on by my learned friend. So let me say a word about it. Rule 88.1 is a general case management power, which can be seen clearly from its terms because it limits its scope to directions which the tribunal thinks appropriate for the case management of the collective proceedings. And the examples given in little 2 show how these relate to directions related to the trying of the case. For example, hearing certain issues together, etc. Case management is to move the case forward. What general case management powers can't do in my submission is to either deprive or risk depriving the class members of part of their damages award. That's not a legitimate exercise of case management powers. It would be ultra vires. And in any event, as I've said earlier, it can't contravene the statutory scheme set out in 47C. It's not a get out of jail free card for the tribunal's jurisdiction. And the same goes while I'm on these rules for my learned friend's reliance on Rule 53.2n. I mean, that rule isn't even intended for collective proceedings. It's in Part 4 of the rules, which are about non-collective proceedings. Coming back to Le Paterel, if we turn through to 375, we see the main issue by C is the account credit issue. And then over the page at 88, under the heading Analysis, by D, the court notes that once an order is made, the tribunal will order for the purposes of distribution who the award will be paid to. We respectfully agree, not for the purposes of the funder. By E, there's nothing to prevent the CAT issuing orders which result in the award of damages being distributed in a form which maximises recovery and compensation for the class. This is the low uptake problem. And then at 89, makes the point that the collective action regime is different, reading over, so to speak, from normal private litigation not only doesn't help, but is actually inappropriate. 92, the aim of the legislation is to address consumer wrongs. 93, final sentence, turning over to 378, makes the point that the court considers an account credit serves to maximise the benefit to the wronged consumer and is consistent with the aim behind the regime, which is to maximise compensation to the class. And then at 93, the last sentence of 93, aggregate damages is a radical departure from the common law. That's just by B. 94, we submit, is also consistent with our sequential interpretation. 1, an award of damages. 2, paid to someone for the purposes or the process of distribution. Now, 98 and 99 are obviously the key paragraphs for today. In 98, the key point we submit is just below J. It said that 5 and 6 provide any damages not claimed by the class be paid to a prescribed charity is inconsistent with distribution by means of an account credit. We reject this submission. Not the policy of the law that damages should be paid to charity. The policy is that as many victims as possible should be compensated, but if an award can't be fully distributed, it shouldn't be remitted to the wrongdoer defendant, should then be allocated to some public interest good cause such as a charity. These provisions are a default arising only if the principal purpose of compensating victims is incapable of being fulfilled. And then 99 is obviously key. We address, for the sake of completeness, an issue that arose briefly. The concern has arisen because the only occasion where costs are expressly dealt with in the context of the opt-in opt-out regime is in relation to the allocation of undistributed damages to charity. Here the law empowers the CAT to make provision for costs in favour of the representatives out of the sum otherwise to go to charity. No difficulty. It would defeat the purpose of opt-out proceedings, which might require third-party funding, if costs orders couldn't be made where an account credit was the chosen means of achieving distribution. Reference to the wide case management powers, it's within its power to ensure that funders and representatives are paid, has a broad discretion to make orders as to costs under Rule 98, could for instance make a sequential order: 1, award of damages; 2, damages defrayed from the award before or after the damages are paid to the representative; 3, residue then to be distributed in whichever method is considered suitable. And then the court notes that counsel for BT didn't seek to argue that there was any difficulty as to costs. Now, my submissions on that paragraph are this. First of all, I've made the point that the issue arose briefly during the hearing and wasn't fully argued. There was also no opposition from BT. Second, the problem with this paragraph is that it proceeds on the basis that the funder's return is a cost within the scope of Rule 98. But costs are expressly defined in Rule 104 of the rules as inter partes costs and have been held not to encompass success fees of any kind, either to the funders or the solicitors. And that's why the class representative isn't relying on Rule 98 in this case. And we take it, therefore, to be common ground for the purposes of today that the funder's return isn't a cost which could be defrayed under Rule 98. Now, that's since been established by the tribunal in McLaren. And I'll just give the court the reference to this because we may need to look at McLaren on a different point later. It's in the McLaren 2024 decision, which is at A19 at page 799, paragraphs 25 to 29. And that establishes in terms that the funder's return is not recoverable as costs in the High Court, therefore doesn't fall within the definition of costs in Rule 104. That would apply to a success fee of any kind, either to a solicitor or to a funder. And so it's not recoverable, therefore, under 98(1). So in this context, for the funder's return to be recoverable, it has to fall, as it does, within the word expense in 47C6.
Isn't the point that this paragraph, being the one who wasn't in that judgment, the paragraph with the tribunal could, for instance, do 1, 2, and 3. That is still contrary to your submission of what the meaning of the section is, even if costs. It doesn't include the funder's fee. That doesn't get you out of it of saying this is actually contrary to your construction of the statute.
Well, we're not arguing here about, so to speak, normal costs.
Oh, I understand that.
Yeah.
But the point I'm putting to you
Sorry.
is that if the sentence that starts with the words, the tribunal could, for instance, make a sequential order that,
Yes.
if that's correct, then your construction of the statute can't be right. And it doesn't make any difference whether the funder's fee isn't costs. It's still contrary to the statute as you construe it. I think that's right. But
Still all comes down to the question of what's meant by section 47C3.
Yes.
And true it is that in this paragraph of the judgment we weren't focusing specifically on that, but what we had in mind was the overall point which is made against you, that whether one's looking at it, here we're looking at specifically in terms of an account credit, but you could have a scenario where the costs, including the funder's fee, were paid before the account credits
Exactly.
were paid out. That was
Exactly.
the point.
Exactly.
So that, I mean, you're entitled to say, the Court of Appeal, that this was over, so that we didn't have full argument. That's absolutely true from recollection.
It
It's
wasn't,
entitled to
the
say,
issue before us. I mean,
it wasn't
that's
really
what I
before
thought.
us, and you're
if you
entitled
think
to
it's
say,
wrong, tell us, yeah.
Well,
you were wrong, and when you've heard full argument, the answer's the one you've given.
Yeah.
I mean,
Well,
that's
insofar, I don't get into the sort of the cost stricto sensu point, but insofar as we're talking here, we're reading cost as being funder's fee, then obviously my submission is that is wrong. But we do say though, I mean, I don't want to make this a curate's egg of a decision, but we do say this decision is supportive of our position as to the purpose behind 47C. Because on a number of occasions, the court goes out of its way to say the principal purpose is to compensate as many members of the class as possible. Now, the point between C and D in 99, i.e. wide case management powers, we say obviously one, any discretion has to be exercised in accordance with the express provisions of the statute. I've made that point. And the funders can only get paid under the statutory waterfall, essentially, baked into section 47C. Wherefore, we do say that insofar as this case should be read as, sorry, let me start that sentence again. Insofar as the word costs in that threefold step would include funder's fee, we say that's wrong for the reasons I've given. That is a jurisdictional point at the heart of this appeal.
yeah.
And I anticipate it to be common ground that this court is able to reach a conclusion that I'm right, because it's not bound by this decision, because it's not on this point and the point wasn't argued.
This issue was 1 or 0.5% of the debate before us at the Petterell.
That seemed to me to be,
No,
if I may say, just reading the
absolutely
decision.
accepted. If you're right, then this doesn't provide a barrier to your argument.
Yeah, exactly. I mean, I'm not here on the sort of arguing for a leapfrog or anything like that. Now, let me turn then to the account credits point, which was really the whole point of Le Patterell. That was really the court's focus. Now, account credits are a case in which there may be not enough left over for the funder. I made the point earlier that the opt-out regime was premised on the idea that on the notion that there would be low uptake. And innovative methods of distribution, such as account credits, if they're ever adopted, because they haven't been yet, would be one example of a situation in which a high percentage of the damages could end up being distributed. Now, even then, it's unlikely to be anything close to 100%, because people will have died or left or can't be found. But I would accept that there would be certainly a higher risk in an account credits case that there wouldn't be enough left over to pay the funder in full. But that goes back to the point in Packard. That's a risk baked into the regime. That's a risk that Parliament has allocated to the funder. And whether
there's an inconsistency. On one hand, you say rightly that the policy is to maximise recovery to consumers, and it's recognised for that there needs to be supping with the devil, i.e. providing funders with a reasonable rate of return. If you don't have that, you don't get any recovery. Well, that's the risk. So Parliament can't have it both ways. So we want to maximise recovery, but we're going to wallop the funders so that there is, in really, really deserving cases where we've got a prospect of 100% recovery, none.
Yeah.
Because the point you know about account credit is, in that case, the BT case, is if account credit works in due course, as it were, there would, apart from as you say, from people who died, or moved abroad or whatever, or closed their BT account, everybody would get their credit. And you might say the same is true, actually, just thinking aloud, and you can tell me I'm completely barking and wrong, in relation to the MIFS cases. Everybody who's got a MasterCard or a Visa card or whatever, one way in which the damages might be distributed is by giving everybody a credit against their next monthly MasterCard bill.
Yes. Well, as
Those of us who've had to forego our £46 in order to hear the many appeals.
well, yes, it's one of the many sacrifices the judiciary of this country make on a daily basis, my lord. But as the court knows, I act for the class representative in one of those cases, so I'm not going to go too much into the detail.
No, actually, I mean, just thinking aloud,
But
it is an example,
Yeah.
is it not, of a case where you could have fairly substantial take-up
Yeah.
by doing it by way of a credit to the account.
Yes, I mean, let me answer that point and also Lord Justice Green's point. You could have a high take-up absent a direct credit point. I've accepted for the purposes of argument today that direct credits are permissible. I mean, formally, I reserve my position on that for obvious reasons. But you could have a direct credit case where, so to speak, you'd expect very high take-up. You could have the exceptional non-direct credit case where you have very high take-up. Now, where one gets to is this, but particularly with direct credit cases, I accept that you could have this position, which is really put to me, I think, by Lord Justice Green, which is posit the case where there's a very good claim, direct credits can be used. So it's a claim which is very likely to succeed, but you can have very high payouts, but somebody has to fund it. Isn't there a problem there, if I can paraphrase the question? And the answer is this. The answer is when Parliament set out the Act, the one thing it wasn't doing was contemplating either cases of very high take-up or two direct credit cases. If I'm right, as I submit I plainly am with respect on the wording of the statute and the policy behind it, given what Parliament was doing, the answer to that is that Parliament will have to think, how are we going to provide for funding in that type of case? There would be a tension at the moment. I absolutely accept that's a consequence of my argument. But what this court can't do is to, so to speak, reverse engineer the position. It can't say, well, because there's this conceptually possible case, which hasn't yet happened, we haven't had a direct credits case yet, we're going to rewrite, and it would be, in my submission, a rewriting of the statute to allow the funder to be paid its return first. Now, and that really goes back to the Professor Mulholland article. The way the regime has been designed wasn't the only option. It wasn't the only game in town. There were lots of games in town. If Parliament had been contemplating account credits, perhaps the regime would be different. Perhaps it would be different in an account credit case. And if account credits are actually ever used as a method of distribution and it causes difficulties of funding, then Parliament may have to reconsider the model. But there's no evidence of that at the moment. Indeed, the evidence is, as in this case, that cases are and will be funded on the basis that the funder will be paid out of undistributed damages. And so that is the answer to my Lord Justice Green. I hope I've answered that question directly. My Lord, I see the time. I was going to say a word about settlement cases and then something on my second ground of appeal. I don't anticipate that's going to take me too long. It might be, if the court is willing, perhaps we could break slightly earlier and come back slightly earlier, if that's...
Well, should we say we'll break now and come back at 5 to 2?
I'm grateful, my Lord.
Court rise in favour.